All the CA Foundation students, very good evening to all of you. I think you must have written today's accounts exam very well. I'm 100% sure because some of the students have already called me and accounts exam really went very well. Then anyway, CA core paper is accountancy, so you must have written well. No doubt, I hope and you hope that you will get 60 plus marks for sure because it's a CA course. There is every possibility. Correction will not be that easy. Correction will be proper. So therefore, that is the meaning. Next exam, I think day after tomorrow, you're going to write on 22nd, you're going to write business law paper. This video is not only for BRICS Academy students, but also in general for all the CA Foundation students. Though my 80% of the objective through this video, I would like to guide my students, especially that is BRICS Academy students. And other students also can watch this, no issues. But make sure you don't leave in between. If in case you're 100% confident, you really have an idea that you can definitely handle business law paper, then fine, don't watch this. But if in case you think that something you're going to get out of this video, please watch. And if in case you think it is 1 hour video, maybe take in between 10 minutes break and continue watching. All right, chalo. So this business law paper, 99%, if you look at the previous question papers, I want to show you in front of you the previous question paper of CA Foundation business law paper. Okay, if you go to ICA website, you have, I just want to analyze, I'm on ICA website. We have previous question papers, new scheme, okay, one scheme is there. So intermediate final is there. If in case, yeah, you have some revision papers, suggested answers, etc. So the latest paper is not yet updated. So because currently you are going to write, I want to strictly follow this material, study material of ICA material. Let it be open like this. Then let me show you and explain some documents, some suggested answers which are given by ICA. I'm taking directly institute material only from the website. Some of you must have already seen this. If you look at the first chapter in the new syllabus, we have got Indian regulatory framework. So there's every possibility from this lesson. So what I'm trying to tell you, this video main objective is this today, tomorrow. I want you to revise the concepts that I'm giving you. I want you to revise the concepts I'm telling you right now. You mentally prepare for two types of questions. One, questions like this, direct questions from this kind of chapters, maybe for 4 or 5 marks, and majority, that means 80% of your question paper is going to be case law questions. So case law questions also, example is given, answers are also given. I'll tell you because answers given by institute, you may not be able to copy as it is, but we can definitely come to a conclusion what institute is actually expecting. So whatever institute is expecting, we have to live up to the expectations of institutes when they correct the papers also in the same way they correct. Because when they gave us suggested answers, it indirectly means that they want you to write and present your answer in that way, right? So when the question is direct question like this, like suppose in the first lesson you have one sample question called what do you understand by Indian judicial system and what are its various functions? This kind of a question, if it is given for 3 marks or 4 marks or 5 marks, my sincere advice, without writing any sections, without writing any relevant sections, you can start writing the answer directly. So he's asking exactly what do you understand by Indian judicial system, what are its various functions. So straight questions. That means in law first lesson 101% you will find only theory questions, that two direct questions. 100% will have one question. Average, I'm expecting at least 100% one question definitely will be there. That question could be for 4 or 5 marks. So he's asking what do you understand by Indian judicial system and what are its various functions? If you go to the answer, question number 1, if you go to the answer, all right. Question number 1, if you go to the answer, so have patience, okay? Anyway, this will definitely help you to have some idea and answer your questions, okay? If you look at the answer here, it says Indian judicial system is a branch which through the enforcement of law resolves dispute between citizens and between citizens and between citizens and the government. That means judiciary is basically Indian judicial system in the sense it's basically law of the country. This law of the country is mainly meant for what? to settle the dispute between citizens, and if in case there is a dispute between citizens and government, right? So how directly, see, now the sample answer is given by ICAI indicates clearly, better give an introduction. That means when this kind of a question is there, make sure you give an introduction. You give a proper introduction. That too, that introduction, don't make it very lengthy. Don't make it very lengthy. You don't have to mug up and remember whatever you studied, because your questions are not going to be exactly how you studied. Your questions are going to be testing your concepts. Therefore, this kind of questions, I'm trying to analyze this kind of questions, always give a proper introduction. I'm trying to analyze what exactly ICAI Institute is actually expecting from the students. Then the next question, if you see, then what are its functions? So functions of judiciary system, in the material also it is there. Regulation and interpretation of codes and acts. That means our judicial system main objective is to make sure what exactly is the interpretation of law, what exactly is the meaning of law, what exactly is the intention of lawmaker, so on and so forth. And the next important function of a judicial system is basically dispute resolution. Next important function is making sure there is a fairness, in the sense when it comes to giving justice to people, you should not show any discrimination. So second part of the answer, if you see directly, it is explaining what is asked in the question. In the question, they've asked function. So make sure you give an introduction, then afterwards directly. So this kind of a question, always you try to go by the question. Just because you know judicial system, you remember something from that lesson, there's no point in writing it unless and until you exactly know what examiner is asking. So strictly follow what exactly examiner is asking. The next one, if you see, Indian judicial system performs functions, etc., general one is there, and they also try to mention that so and so article 141 talks about the what you call high court role, supreme court role, etc., etc. It says all the judgments given by what do you call, it says the decisions of high court, decisions of supreme court are binding on all high courts, etc. Supreme court judgments are binding on high courts, high court judgments are binding on local courts. Okay, they gave some explanation. So whenever theory question is given like this, first briefly give an introduction. After giving an introduction, make sure you so that means after giving an introduction related to that concept, next two paragraphs, you must be able to mention exactly what is asked in the question. See, there are any points? No, only because functions, objectives, rules, regulations, that kind of questions are given 100%. You have to write the points. Understood? So I mean to say, in business law, when you want to answer a question, make sure you divide your question into your answer into three paragraphs. First one, you explain the concept. Next one, you straight start answering what exactly question is asking. Okay, that is one thing. Let's see one more theory question. Let's see if there is any theory question, because most of the other chapters, if you see in a sample also, they have not given any theory question. Like you see here, state the modes. 17th question, you see, state the modes by which a partner may transfer his interest in the firm in favor of another person under the Indian Partnership Act 1932. What are the rights of the transferee? The 17th question is related to Partnership Act of 1932. This is exclusively talking about, can an existing partner transfer his interest to third party? If in case an existing partner wanted to transfer his interest, his share to third party, what is the mode? He's asking what is the mode. And the next important thing is, what are they? Suppose if a partner who transferred his interest to outsider, the outsider, we know in the concept, outsider is called transferee or sub-partner. That means outsider who actually shares the interest of the existing partner in the firm is called sub-partner. So this is a direct question. So this direct question, my two questions only is asking, better tell me what are the ways and modes how you transfer. This is how you need to. So in every question, there's going to be a keyword. In that keyword, you need to understand and come to a conclusion what exactly he's asking. He's asking only two questions. Boss, tell me what are the modes a partner can transfer his interest with outsider. The outsider will be called as a sub-partner or a transferee. And later on, second question, what is he asking? Better tell me what are the rights of such transferee. So like this, you have to come to a conclusion. What are the key terms in the question? So you strictly explains about, first of all, this kind of a partnership happens when, if in case an existing partner wanted to transfer his interest to anybody, what exactly is the mode? And what are the rights of such transfer? This kind of a concept is related to sub-partnership. So let's see 17th question answer in front of you. So Question keyword is what? How do you transfer? How an existing partner can transfer interest to outsider, and what are the rights of what outside person whoever shares. So it's like a situation where sub partner, existing partner is trying to transfer his interest with outsider. Existing partner is trying to transfer his interest with outsider. If in case he wants to transfer, how does he transfer? So the first important paragraph is you have to see question answer is started with section only. If you do not remember the section, you don't write. For this kind of a question, if you do not remember section, don't write, but at least you start writing as per the relevant section of Partnership Act of 1932. But trust me, if you could write the section 101%, you will have better marks. No doubt about it, because the valuator will try to test your legal knowledge in this case. So first paragraph, if you see carefully, it is trying to explain what section in Partnership Act of 1932 clearly states that the person, a partner in the partnership, can transfer his interest to outsider. It says as per so start your answer, start your first paragraph like this. Provides that the share in the partnership is transferable like any other property. See the keyword? That means just like you sell your property, you also can sell your interest. But partnership is a relation between partners, etc. Okay, the assignee of the partner's interest by sale or no cannot enjoy same right. That means since it's a partnership, it came into existence through agreement. Since outsider has never been a party to the agreement, the assignee to whom the rights are given may not have the same privileges and rights. The reason is very simple. The reason is very simple because he is not a part of the agreement. Yes, then see, simply speaking, he is not even trying to explain who's this partner. So he's trying to say which section enables an existing partner to transfer his interest to outsider, and also indirectly concluding that the outsider, since is not a party to the agreement, outsider, the sub partner, so-called, he's called as, he is not a party to the agreement. He's not going to enjoy all the privileges of the partners. And straight now rights of the transferee is given. So transferee is a person to whom existing partner has transferred his right, is a sub partner. Now there are two important, see how is it dividing, you see the rights during the continuance of partnership and on the dissolution of the partnership. So as long as partnership is alive, what are the rights? Are there any rights to transferee to whom existing partner has transferred? My point clear? So during the continuous, that means when the partnership is alive, what is the story? Transferee, the sub partner, cannot interfere in the conduct of the business because he has never been a part of the agreement. He cannot even ask accounts to be inspected. He cannot even ask, he can't ask accounts, he can't inspect accounts. So this is the right. That is indirectly we say, instead of writing he doesn't have any rights, we are saying that he can't ask for accounts, he can't inspect the books of the firm, he can't even interfere in day-to-day activities like an active partner. But next paragraph he says he's only entitled to receive his profit. He's only entitled to receive his profit. Is my point clear? He's only entitled to receive his profit. Understood? Of the transferring partner, he is bound to accept the profit accepted by the partners. He cannot challenge the account. So indirectly we say sub partner is a partner to whom existing partner has transferred his interest, and that sub partner, or he is also known as transferee, he is not supposed to interfere in the conduct of the business. He cannot ask the partners to show accounts. He can't even inspect the account. He is only entitled to share the profit which has been agreed by the partners or that partner. So this kind of partnership cannot happen unless and until he has taken the, I mean, transferring partner must have taken the consent. So we started the answer with the section because we know the provision. If in case you don't know the provision, as per the relevant provision of Indian Partnership Act, don't mug up the sections. Try to remember, because see, CA is a difficult course. CA is a tough course. You must have heard so many things, right? So when it is a tough course, then you got to be tough. When it is expecting something, ICA people, institution clearly mentioning, better, this is how we expect the answer, then stick to that plan. After writing this, you question, no, if in case you could present your answer according to their pattern, according to their model, then afterwards, if you don't get the marks, you question. They don't simply prepare question paper, they don't simply prepare value papers just like that. My point clear? Yes. Second one, you see, suppose I'm a sub partner, means I'm a transferee from whom, from existing partner, I'm taking some share. So at the time of dissolution, what happens? So see there carefully. If an existing partner has transferred some interest to outsider, then the question comes, there is every possibility existing partner may retire. What if the partner who transferred his interest to outsider retired? What if the firm itself is dissolving? Then in such case, what are the rights? See there, he has the right to receive the share of the assets of the firm. That means whatever, like existing partner has agreed to share, let's say 20%, 20%, that 20%, whatever is there, he has every right to ask the other partners to settle the account, right? Next one, he has for the purpose of ascertaining the share. That means he has every right to ask, boss, you please, my share, I'm sharing from existing partner some 20%, equivalent to 20% assets also, he will have a right. So does he have a right over the assets at the time of dissolution? So other partners must definitely estimate the valuation and settle his account. He is entitled to an account from the date of dissolution. 100% his account. Finish. Yes. And next paragraph, you see, by virtue of section 31, no person can be introduced as a partner without the consent of all. Indirectly, it says, beta, if you want to become a sub partner, you cannot. That means existing partner cannot transfer. So section 29 and section 31 is connected here. A partner cannot, by transferring interest, make anybody else as a partner. You can't just transfer your interest and make outsider as a partner unless and until consent of existing partners is given. And it also says at the same time, partner is not debarred from transferring. I mean, I'm not saying law doesn't say, section 31 doesn't prohibit that he can't transfer the interest, but he can transfer, but only thing is with the consent of all the partners. So a partner's interest in the partnership can be regarded as an existing interest and tangible property which can be assigned. Beta, I'm not saying that you can't transfer your interest to anybody, but I'm only saying, we are only saying that you transfer with the consent. Once you take the consent, 101%, you're going to have, the outsider will have some rights, especially at the time of dissolution. He will be entitled for settling of his account according to the share that is given. So see now, see this answer style I'm telling you. First, they explained whether this kind of a partnership exists according to which section, then rights during the continuance of partnership, rights at the time of dissolution. Then lastly, if in case this paragraph, even you can write in the first one also. First paragraph itself, this paragraph you can write saying that as per section 31, an existing partner with the consent of all the partners, he can definitely transfer his interest to outsider and is not debarred, means is not prohibited from transferring his interest. However, you can assign your interest to anybody, but only thing is you have to take the consent from other partners. You have to sketch out the answer like this. Let us look at one more question. If you want, let me know. I will WhatsApp you this. Otherwise, it's there on ICAI website. Please download. Okay. One more question. I'll check. Let's go to Contract Act. Indian Partnership Act. Okay, so a lot of questions will be like this. Let's go to Contract Act. One Contract Act question we'll see. Okay. In Contract Act, fifth question, you see. Fifth question, may examine whether the following constitute a contract of bailment. In the new syllabus, you have got at the end of Contract Act, you have got agency contract, you have got bailment, you have got pledge, you have got lien. There are some special contracts. Go through them. 101% you will have one question from there. Especially agency contract and guarantee contract is very, very important. Looking at the volume of the syllabus also, those two concepts are very important. He's giving like Vikas parks his car at the parking lot, locks it and keeps the keys with himself. This will immediately strike me one thing. What is actually bailment? Bailment is voluntary transfer of possession of goods to another person. Bailment happens when one person transfers the possession of goods without transferring ownership, either for safe custody or for some specific purpose. But here, Vikas parks his car at a parking lot and locks it and keeps the keys with himself. That means my first important question, bailment may, teacher said very clearly, voluntary transfer of possession of goods. Where is the transfer? Where is the transfer? But then I park the vehicle in the parking lot, whether a parking running person is responsible as a bailee or not. Bailee is a person to whom we gave goods for safe custody, right? But here, where is the question? That's what, okay? What losses you have to come to? This kind of examples, they can ask you anything. Then seizure of goods by custom authorities. Customs tax authorities have taken the goods from you. You did not deliver, they took it off. So, but bailment clearly says, but a bailment happens only when one person has voluntarily transferred possession of the goods to another person, either for safe custody or for specific purpose. Once the purpose is accomplished, the goods which are given to him have to be returned as they are, with according to the directions. You have to return them to bailer, bailee. But both the points are contradicting our concept itself. First case, he parked the vehicle, he did not give keys, also he did not hand over to anybody. Second case, I did not give, but tax authorities have taken the goods. Tax authorities have taken the goods. Is my point clear? Fifth question answer, you see. Fifth question answer. Just go through these questions from ICA website if in case, yeah, fifth question. See there? As per section 140, see, I want to remind you, beta, out of 10-15 questions, if you could answer few questions with the sections, I'm pretty sure you're going to get some good marks. Institute cannot simply misguide students. They won't misguide students. They are telling Vesa, this is what we are expecting from you. This is what we are expecting from you. Follow this now. What we expect, you don't follow, and you always go by your own opinion and come to conclusions that this is how answer is to be given. No. Nobody knows exactly valuation, because if in case you want to see your answers, if you got less marks, there's a possibility you can apply for answer skips and check. That time you will realize. So let us take some precautions now. So what you are supposed to do now, take all the consideration, take the sections, capacity contract, take the sections, free consent, take the sections. Understood? Performance of contract, take the sections. What do you call a discharge of contract, take the sections. Coercion, take the section like section 14, 15, 16, 17, 18. First section like section 10, 11. This one, essential elements of the contract. Like this, sketch out what's wrong in sketching. Last minute, we don't know. You are there to study. You are there to write exam day after tomorrow. Do something today. What's wrong in studying today 10 hours, tomorrow 10 hours? What's wrong in tomorrow? Just 8 o'clock you sleep. Tomorrow evening 8 o'clock you sleep. Yeah, today's 20th, 21st, 22nd you have an exam. What's wrong in going back to all the concepts and sketch out the sections? There's nothing wrong. Important concepts. I will tell you what important concepts where you are supposed to see in this video itself. So first paragraph, it says what? As per section, bailment is delivery of goods from one person to another person. Understood. For a purpose. Once the purpose is finished, the goods either have to be returned or disposed as per the direction. So bailment happens only. So first paragraph, I'm not trying to explain the concept here. I'm trying to tell you how the answer has to be. How the answer has to be. So this kind of a question always begin with the concept. So what to do, sir? Now hammer now. This whole night you do, tomorrow for 3-4 hours till 10 o'clock, 11 o'clock you sleep. No, sketch out every concept. I'll tell you the concepts in this video itself. What concepts you have to go and look at the sections now. Thoda, without having any diversions, without having any tensions, negative. You already had studied. If you had already studied, sketch out now. Keep them in order. Understood? So it says for bailment to exist, bailer must give a possession. So indirectly, you explain the concept according to what section is bailment. So bailment, basic no, agency, what is agency? 182, you have to remember. Guarantee, what is that? 124, you have to remember. Indemnity, what is there? 123. There is a main consideration, at least 23, you have to remember. There are some basic concepts in contract act, sale of goods. That basic concepts, if you know conditions, warranties, you have to remember that section. You got my point? Transfer property, you have to remember in every lesson there are some basic concepts. No, start sketching out. Tuck, you work for 2 hours, you will get. Don't have attention, you don't remember. If out of, let's say, 50 sections, how many other sections you want to remember, you remember. But my objective is, by not writing section, you may not fail completely. Even 50% pakka you will pass, don't worry. But by writing sections, our chances of getting more aggregate marks will increase. So therefore it says bailer must give possession. Now you see answer. 2 questions are given. So when such kind of questions are given, after explaining the concept, next answer each question separately. Because if you're not answering what they were, simply some of you, some students, what generally they do, they mix both the answers. Yes, they will start. No, they will start. No, that is not the correct way. First important thing, you have to explain the concept and write the section. Afterwards, whatever he's asking, stick to the answer and start writing. So it's a mere custody of goods does not mean possession. I said bailment is about transferring the possession. In the given case, since the keys of the car with Vikas, section 148 shall not be applicable. Crystal clear. Because when you know what is a bailment, transfer of possession of goods, mobile property from one person to another person for a specific proper purpose, after that purpose is accomplished, he or she has to return the goods as they are, or they have to be returned as per, they have to be disposed as per the direction. So that is not satisfying. No. Where is the question of delivery here? Next one is, yes, the possession of goods is transferred to custom authorities. Therefore, bailment exists and section 148 is applicable. Second question is content. It says possession of the goods is transferred because tax authorities will not request, you gave the goods. You gave the goods. Goods are delivered to, because they came, they asked, you deliver the goods. You got my point? Slightly this kind of issues will confuse you. So similar kind of questions, if they ask, make sure you write the answer like this. Is my point clear? Sixth question also, you see in the practice questions, one more question, let us see. Sixth question. Then I'll tell you in each topic what sections you are supposed to go through today, so that this time you can utilize accordingly. Okay. Sixth one is, Mr. Sanjay Kotari was a big businessman having two sons and one married daughter. He decided to gift his house to his daughter. I'm telling you, when you start reading a question like this, first slowly, after reading one or two lines, come to a conclusion. What exactly is the concept connected? Is it related to capacity to contract? Is it related to consideration? Is it related to coercion? Is it related to free consent? Is it related to undue influence? Like this, you have first 3-4 lines only, you can come to a conclusion. What exactly is the concept connected to this question? Then for this purpose, he called his lawyer at his house and made a written document such as gift. The lawyer advised him to get transfer document properly registered. Oh, so he's trying to, family member is giving a gift and he also advised him to give it in writing, and it should be in document in the sense it is writing, etc. When they both were going for a registration document, they met with an accident and both died. Later, the daughter found the document and claimed the house on the basis of the document. Explain whether she can get the house as a gift under so and so. Your logical question, I'm telling you. Logical question is, gift is already, see there, what happened? Third line, you see. For this purpose, he called his lawyer at his house and made a written document such as he made already. The lawyer advised him to get the transfer document registered. That means he made a document, he signed. The donor has already signed. First of all, it's an agreement out of natural love and affection under consideration. An agreement made out of natural love and affection is valid only when it is in writing and registered and people are nearly related. He's asked that what happened actually in the case. So first one, it is related to consideration. Second one, it is related to whether gift is valid or not if it is not registered. So according to consideration, one very important point in the consideration, natural love and affection it is valid only if it is given in writing. Let's see the answer. Question number 6. So what is he asking question? Whether she can get the house as a gift under whether gift is valid or not. Okay. So question number 6. Answer, let's see. Simple answer is given, but I'll tell you what to add here. So just section 25 provides that an agreement made without consideration is valid if it is expressed in writing. That means an agreement. So this question is related to what I said, like you have gifts given, agency creation, agreements made out of natural love and affection, gifts completed, consideration may, exceptions are there. You remember? When you know the concept, what are the exceptions under which an agreement is valid even without consideration? So general rule of the agreement is basically an agreement without consideration is void. But there are some circumstances where agreement is valid without consideration. Agreements made out of natural love and affection, gifts completed, agency, remission, past voluntary services, time bar debt. Like this, you have some concepts. No, that concept. Consideration, only 3 concepts are there. What are the legal rules for valid consideration? What are the exceptions to consideration? What do you mean by privity of contract? What are the exceptions to privity of contract? So consideration में three concepts are there. Three concepts, three sections, you remember. So section 25 says an agreement without consideration will be valid if it is expressed in either writing and registered. And that too, these agreements either if they are made on account of natural event affection. You remember I told you. So in consideration may, general rule exceptions may, even in my running notes when I was explaining the class also, I told my students, first one only we studied any agreement which is made out of natural event affection, you should satisfy three conditions. Number one, relationship should be near, it should be in writing, and it has to be registered. Then such agreements are 100% valid without even consideration. You can change the language. You don't have to, if you're not able to write legal language, it's okay. Use the concept and write. Next one, in the given case. So first you have to explain, but briefly for this answer to expand what you can do, you can write in the following cases, agreements are valid even without consideration. You can briefly write agreements made out of natural love and affection, past voluntary services, time barred debt, agency, remission, gifts completed, charity, etc. Few in 2 lines you just explain. Then you can say in the second paragraph, you can say in the given case, the agreement made out of natural love and affection, and parties are standing near relation with each other. Agreement is written in is given in writing, but it is not registered. They are that their second paragraph will. Then third paragraph will say, therefore, this kind of transfer is not valid because one condition is satisfied. Two conditions only satisfied. One condition is an agreement made between near related people. Second condition, it has to be in writing. That is also satisfied. But the last condition, which is very important condition, that it has to be registered, is not. So therefore, his daughter cannot get this house as a gift. Gift is not valid. Okay, spontaneously you develop the answer. 3 paragraphs. My sincere advice, don't write the answer in 2 paragraphs. First paragraph, you write the concept. Second paragraph, you explain what actually happened. And the third paragraph, then conclude. First paragraph itself, do not start the answer. And do not be afraid. Keep writing because you did 2 things so far. Number 1, you attended classes. You attended whichever teacher, whichever class you attended classes, means you know concept. Second important thing is don't have a tension that you don't know. Spontaneously you have to write the answer. And rule is very simple for practice questions. Make sure first paragraph begin with the section today night itself. Today and tomorrow, make sure you put them in order. One day is a golden day that is given to you, extra time. You already had studied, you don't have to be afraid. Only thing is you have to align, okay, so and so famous concept, what? I'll tell you now what are those famous concepts for which you have to remember sections. And divide that answer into 2 or 3 parts. First paragraph, explain the concept if you know the section, then, but don't try to write wrong section. That's what I'm telling you. If in case exactly you don't remember the section, my sincere advice, as per the relevant section of Indian Contract Act 1872, this is so and so concept, because you might be knowing the concept, but you don't know exactly what is the section, then fine. And conclude clearly. Do not move away from the question what is asking. Stick to the question and answer. Got my point? Now so this is how you have to go through the practical and theory questions. Get ready for more of case law questions. So therefore, spontaneously you can answer. You have to align the sections accordingly. Now, in Indian regulatory last minute revision ke liye, I'm trying to tell you from the study material. Open your study material. And last minute revision ke liye, you want something to be revised today itself. So last minute revision ke liye, I'm not saying these are important questions. I'm only based on my experience, based on the previous question papers. I'm trying to tell you better before going for exam. Last minute thoda dekh lo. Okay. Okay. So first, in the first lesson, please refer sources of law. All right, tick mark in your textbook if you have a textbook right in front of you. Sources of law. Then types of law. This one also you go through. Okay, types of law. Then please go through this departments. Ministry of Finance department, Ministry of Corporate. 2 departments are there. Ministry of Finance and Ministry of Corporate Affairs. 2 departments. Go through that. Ministry of department, Ministry of so and so. Okay. This one. Okay, then go through slightly Reserve Bank of India and SEBI. Slightly Reserve Bank of India and SEBI. Okay. Then structure of Indian courts may you just briefly read what Supreme Court can do, what High Court can do, what district courts briefly. So this chapter may more Reserve Bank of India revise, SEBI you revise, out of SEBI Reserve Bank of India you revise, then Ministry of Corporate Affairs, Ministry of Finance you revise last minute, and sources of law, and briefly about High Court, briefly about Supreme Court. All right, that is one thing in that lesson. Then if you go to Indian Contract Act, these concept sections you align carefully. Okay, nature of contract may, if you see, nature of contract may, if you see, wait a second, instead of without wasting time, wait a second. Essential elements of valid contract. This essential element of valid contract is there in section 10. Okay, briefly go through. There is a possibility 6 or 7 marks theory question they can ask you. All 10 essential elements may at least 3 4 lines without writing examples you can write. Okay, essential elements you go through. Okay, in the types of contract, my advice, go through contracts based on enforceability. Contracts, definition sections, if you don't remember, it's okay, but make sure these concepts you remember. Okay, next one, briefly, you should be able to write 2 3 lines. Okay, based on enforceability. Next one, you have a question, theory question they can ask you, essential element of valid offer. Essential element of 6 7 essential elements are there, go through. All right, next one, also try to know, revise last minute may, just in 5 or 6 minutes may, the difference between intention to offer, invitation to offer. And lastly, in this one, so just like you read the rules for valid offer, similarly rules for valid acceptance you read. Finish, that is in that lesson. Yes, next lesson, if you see, keep marking. Okay, next lesson, if you see, that is consideration. Consideration is very important. You cannot imagine law question paper generally without consideration unless your fate is so bad this year. But usually you will always have questions from consideration, and it's one of the easy topics. So make sure you write with the sections. So consideration may, if you see, there are 3 important concepts in the boxes itself. One is what are the legal rules for valid consideration? Okay, number 2, what is the general rule that no consideration, no agreement, but what are the exceptions? Just now we studied. Then this one, these 3 points you remember, but reading is okay, easy, but make sure you remember the sections. Okay, if you go to consideration, so this one, okay, privity of contract, right? Next, privity of contract exceptions you go through. Then this one, section 25, this is very important. Under what circumstances consider agreement is still valid without consideration? Okay, and they have given, see, end of the material, law latest material, may end of the material they give crystal clear. First you do one thing here, since you already studied the syllabus, end of the chapter there are beautiful, you don't have to refer any material. Institute material is an amazing material. You please go through this revision at the end of the chapter, go through it. This will help you. If in case you have a doubt what exactly I should write for trustee or family agreement, you just go and look once so that you will have an idea. Okay, that is one thing. So mostly exceptions to general rule plus privity of contract, both. Other essential elements may, my sincere advice, don't leave. Other essential elements, here itself I'm telling you, other essential elements may, coercion don't leave. And minor related, capacity to contract may, minor related rules regarding minor is there. Section 10 and 11 go through. Then here fraud, coercion, undue influence, fraud. These 3 are frequently asked questions. If you know fraud, you have to think about misrepresentation, reverse. Okay, that is one thing. So please go through it. And one more thing here. So here in this lesson, go through minor related rules, go through coercion, go through undue influence, go through fraud, 3 continuously. Okay, last minute revision. I'm not saying to avoid other things. Okay, if you have a time, you can revise. And in these 2, lawful consideration, like 6 reasons are there, no, fraudulent, forbidden by law, etc. That section also remember in this. Okay, understood. So what is your job right now? Coercion, what is the section? Okay, section 14. Okay, undue influence, section 15, fraud. sorry, 15, 16, 17. So 13 onwards, it will start, no, consent, then free consent 14, then 15 onwards, it will start. Okay, like this. So what all sections are there here? You see, capacity contract के बाद some 13 section to 14 section, make sure you remember. Now here you see this paragraph. So free consent is 14, then 15 is coercion, 16 is undue influence, 17 is fraud, like this. That is one thing. Next one, if you look at performance of contract may here chart only I'm telling you. Okay, so please make sure you read thoroughly about performance of reciprocal promises and time and place of performance. Time and place of performance of contract, performance of reciprocal promises. And over here we have something called contracts which need not be performed, like novation, recession, remission, waiver. And okay, that is one thing. When it comes to discharge of contract, modes of discharging contract, sections, I'm telling you to analyze. I repeat once again, time and performance of contract, performance of reciprocal promises, then contract which need not be performed, sections you see carefully, and discharge of contract mean modes of discharge of contract. Yes, that one you go through. Then if you look at breach of contract may here over here itself, difference between anticipatory actual breach you go through once. And do not skip remedies for this lesson. Pura heart is remedies for breach of contract. Briefly, what is ordinary damage, what is special damage, two lines information you try to have in this lesson. I'm telling you 101% you will have one of these questions for practical, like suit for damages, recession, etc. So this chapter is highly important. I mean, I'm telling you 100% guarantee question. Performance of contract and discharge of contract, remedies for breach of contract, 100% will have questions. Okay, mostly you can skip only in between. Maybe you have legality of object in consideration. Few cases they may not. Okay, that is one thing. Then if you look at what you call contingent quasi contract, don't ignore here. Quasi contracts, don't ignore. See the chart here. Quasi contract, first of all there are only two, but here 99% you will have to remember quasi contract sections, contingent contract sections. You see contingent contract section 31 onwards. So each point you have some essential elements of contingent contract. Afterwards you have examples also. Here examples are there, you see. 31 is contingency, 32, 33, 34, 35, 36. As a bunch you remember. You know this logic very clearly. First one, happening of an event. Next one, non-happening of an event. Understood? Third logic, first one happening, non-happening. Next one, if the event is impossible. Okay, next one, fixed time, happening within fixed time. So happening, non-happening, in that in between impossibility is there. Next, happening within fixed time, not happening within fixed time, like this. Okay, 35 section only is there, you see. 36 may impossible events, like this you remember. Okay, in this the middle one, especially if you see the I mean, you need to understand impossibility of conduct. If in case a promise has been made on conduct of a person, if the person's conduct changes, so happening, non-happening, person's conduct, then happening within fixed time, non-happening within fixed time, then impossible events, like this you remember. Sections put it in perspective. Section that as a bunch you remember. All right, that is one thing. Quasi contracts may 5 examples are there. Please do not forget to remember this section. Sections also clearly given. Quasi contracts will start from section 68 to 72. 68, 69, 70, 71, 72. First one, necessary supplied to incompetent person called minor. Next one, payment made to interested necessaries, payment made anybody who's enjoying non-gracious services, and finder of the lawsuit. Last one is if you have delivered something by mistake. Align the sections and go through all the sections, because any single section also they can definitely ask you. Work on this section 68 to 72. All right, that is one thing in this lesson. So both you have to focus. Then we have contract of indemnity. My sincere advice, contract of guarantee section you go through. Contract of guarantee, contract of indemnity is very easy. One reading you give, you have already read. So 125 section is related to indemnity related, and 126 onwards guarantee contract starts. So remember this 126 section. Over here, basically what they can ask you maximum, if you could see, what you call rights of surety, under what circumstances. I'll tell you here, wait, to get specific guarantee, continuing guarantee. Okay, that is one general thing. You just go through specific and continuing guarantee. Nature and extent of surety liability. This is 128 section 1 section, you remember. Then discharge of surety. Discharge of surety 130 onwards. Okay, there are 3-4 points. No, 130 like this. Okay, 130, 131, 133. Remember that. Okay, discharge of surety is very important. Next, personal liability of surety, where surety cannot be discharged. And so my question is, in special contracts, make guarantee contract, mash it off. Pura whatever is available in guarantee contract, trust me, put all the sections in order. Okay, rights of surety. So surety liability, surety rights, surety discharge. So focus more on the surety. Put all the sections in order. Work now. 1 hour it takes hardly. You can easily get. If you, I'm telling you, many people in theory subjects like this might fail with 4 or 5 marks. That 4 or 5 marks will help you like this. Rights of co-sureties, you don't have to. Okay, that's it. So mostly guarantee contract you go through maximum. Then bailment pledge may, bailment and pledge is easy, but still, since bailment questions are being asked, just go through. But agency contract. So in 7th, 8th, 9th lesson, may last minute revision, you have to do guarantee contract, everything, agency contract, everything. And get ready for these lessons, case law questions only. So sections, put it in order. Last minute, if you don't remember sections, don't remember, but remember, try to remember whichever sections you can remember, instead of trying to mug up now. Now you only have to go back and look what are the main sections. Okay, that is one thing. So in Contract Act, you can do that. Whereas in Sale of Goods Act, last minute theory questions or any other questions, if you think, conditions and warranties lesson, make sure you go through conditions and warranties, complete second lesson, conditions or everything, implied conditions, express conditions, you go through. And here transfer of ownership by third party is there, and rules of delivery is there. I repeat, conditions and warranties, transfer of property by third party, conditions and warranties, and transfer of property by third party, and rules for delivery of goods, and last one, rights of unpaid seller against the goods, against the buyer specially. At the most, in first chapter, you just go through the difference between sale and agreement to sell. In the first chapter, sale and agreement to sell. Second chapter, implied conditions and implied warranties, thoroughly with examples you go through. Implied conditions and implied warranties, thoroughly with examples. And in transfer of property, most important thing is under what circumstances third party can transfer, and what are the rules of delivery of goods. And unpaid seller lesson may rights of unpaid seller against the goods, that is lien, right of stoppage, and right of resale, and right of a seller against the buyer personally. Yes. Partnership and LLP, if you look at partnership again, out of 3 important, second and third, a relation of partners, rights, liabilities, etc. you have. And first lesson is very simple. If you had read once, you don't have to waste time again. But second lesson, third lesson, especially dissolution of the firm and relations. So 99% of the previous question papers, if you see, there were questions on second lesson. So second lesson, thoroughly you go through, and dissolution of the firm. Registration and general, what you call essential elements of partnership, these are all clear. And when it comes to relationship, incoming partner, outgoing partner, retirement of the partnership, insolvency of the partnership, minor related, the relation, second lesson is a very important lesson and is a bulky lesson. Majority of the questions may come from second lesson. And dissolution, settlement of accounts, etc. you go through. All right, that is one thing. Okay, section. So my simple LLP is one question only. That's company law. You see, company law may, my sincere advice, I want you to go through company law may, wait, applicability. This you go through, please. Theory question, there is a possibility. Applicability of company law 2013. Okay, next one, Separate legal entity for practice question you go through. Separate legal entity here, sections company law mein, LLP mein, partnership mein, don't worry about the sections, but write sections in contract act and this one, sale of goods contract act, right? Next, these are all general features. Corporate will, there can be one theory question. What do you mean by corporate will? Under what circumstances corporate will may be removed? Even practical questions can be asked. And Solomon versus Solomon case, once you go through that similar question, case law, they can ask you. Okay, briefly check the revision material. See here, this map is very important. Under what circumstances corporate will may be lifted? All right. This is one thing. Next, types of companies. May one person company, just go through all the characteristics of one person company. Yes, and privileges of one person company. Private public companies you can easily manage. Manage in the sense you must have already gone through. Next, holding company, subsidiary company, go through for practical questions. Holding company, subsidiary company, go through for practical questions. So examples you go through. Next, government company also please go through once. Section also. Section 8 company, one person company, government company, Section 8 company, holding and subsidiary company. One person company, government company, holding and subsidiary company, Section 8 company. That is non-profit company. Okay, like a complete history of Section 8 company go through. Next, conditions for institutions. Yes, mode of registration. This is all general information. Effect of registration, section 9. Once you go through practical question, there is a possibility. Capital may, this is easy anyway, even if it is given. Shares will be numbered, transfer, preference share capital, memorandum of association contents you go through, all 6 clauses and tables. Memorandum of association contents and six clauses and tables you go through. Okay, this tables and this one, memorandum of association. Each clause you go through. Here comes the very important doctrine of ultra vires. Pura concept thoroughly go through. Sections don't worry, no need. These are all concepts. These are all concepts. Okay, that means most importantly sections you have to prefer Indian Contract Act, because 4 questions will be asked, and sale of goods. These 2 chapters focus on the sections. Rest of the chapters it's okay as per the relevant section in Partnership Act. If you remember, minor section in Partnership, section 30, some popular concepts are there, remember, like retirement of the partner, dissolution of the partnership, dissolution of the partners, that kind of sections. Don't try to, okay, but company Contract Act, sale of goods, maximum number of main concept sections, try to remember, use them accordingly in the first paragraph. When it comes to company law, directly start writing the concept, no issues. This doctrine of ultra vires and this case law also you remember, I mean, go through once, it will help you. Okay, exceptions to doctrine of ultra vires. Doctrine of indoor management, doctrine of ultra vires, doctrine of constructive notice, doctrine of indoor management. These 3 here. Doctrine of constructive notice, you know this concept, right? Doctrine of constructive notice means we presume that the outsider, whoever deals with the company, has understood and read these 2 documents called SONs. So this doctrine of constructive notice, doctrine of indoor management, highly important. Last minute, highly important. Doctrine of ultra vires, doctrine of indoor management, doctrine of constructive notice, last minute revision may in company law, highly important. Exceptions, everything you got. Right, guys? So just go through that question paper which is there in the ICAI this thing. If in case you want, you can download from ICAI website. When last but not the least, law is a kind of subject which is trying to test your concept knowledge. When they give you 80 to 85% of the case law questions, they are trying to test your understanding. So first you arrange answer in such a way. First paragraph, try to give a concept. If you know the section, start with the section, and then second paragraph, try to explain what exactly is the issue in the case and what exactly happened. Then lastly, taking the above situation, you don't have to put a heading concept, facts of the case, conclusion, that nobody worries. Nobody worries. If you put, it's okay for your satisfaction. But my advice is break your answer into paragraphs. If in case there are functions, there are regulations, points to be written, write points, but it is better to write in paragraphs. First paragraph, second paragraph, third paragraph. Number of lines in first paragraph sometimes will be more. So your first paragraphs, last paragraph lines will be more. Understood? That's how you have to answer. Since they're trying to test your understanding, you don't have to worry whether you remember or not. When you see the question, bring back everything, start writing the answer. Most important thing in law, do not read the second question if you know the first question. When you read the first question, if you know the answer, start answering the question. Do not read the second question, because first question could be from one topic, second question could be from one topic. Your mind will start swinging in such a way, it will clash. Because first of all, 3 hours time is there. We don't have to waste even 1 minute time. So therefore, you read the first question, you're 100% comfortable, start writing the answer. You read the second, suppose if you're not comfortable, that means you have to be 100% comfortable. I can do justice for this question, so let me attempt. If in case you are not comfortable with the first question, there's nothing wrong. Properly write the question number and section number, like question number 1A, question number 1B, or 2A, whatever order is there, you write. Then question number 2 you read if you are 100% confident. After writing all these theory questions, at which you are 100% confident, then there is a time after 2 hours or 2 hours 15 minutes के बाद last 30-40 minutes में whatever questions you left, since you have attended classes, since you studied law, there is every possibility at least some 5% or 10% of the answer you can do. Last minute you do that. In this way, if you could present your known answers first, you will be able to secure 50 to 60 without any problem. But if you start writing everything, though you are not 100% confident, you are wasting time, and you might not get enough time to answer the last question. Maybe you're good at answering that question. In this way, let's say if there are 10 questions, if you could answer 6 questions, or 15 questions, if you could answer 10 questions thoroughly and confidently, you will get good marks. And the remaining also, when you are attempting again the questions which you left, make sure you start writing the number carefully and answer carefully. Don't worry, you studied, you understood. This is a mind game. You have to play with your mind. No tension, nothing. And luckily, ICA Institute is conducting exam almost 3 times a year. That does not mean you have to fail now. We are not failing. We are not going to fail. You attempt confidently, spontaneously write the answers. All right. All the very best. God bless you. Take care. Good night.